How do you initiate the process to go to trial?
There's an official state form called Application for Mediation or Hearing. At least I think it's still called that.
It is.
We don't even really have mediations, that official ones anymore.
They've not changed the title.
And that is a form, it's sort of a simplified complaint. And by complaint, I mean the name of the document that would be filed for a full-blown circuit court case where the plaintiff has to set forth many things. The state has prepared a more simplified one-page, two-sided form where you list the date of injury, the employer, you have a brief area in which to describe your injury, you list the treaters you had. It's very formulaic and it gets all the basics of the case on one sheet. That form is then filed with the state. The state then sends a copy of it to the employer listed. The employer often will send it either to their insurance company and or their attorney, and then those other parties get to work on deciding whether they're going to pay or further dispute your case.
Once that case is processed by the workers' comp agency and sent out to the injured worker, to his lawyer, to the employer, to its insurance company, and ultimately by the employer or the insurance company to the lawyer, what happens next in the workers' comp claim process?
It starts getting into the trial system. The first thing that will happen before a workers' comp judge, who's called a magistrate, will be what's called a pretrial conference. That you'll get an official notice in the mail from the state saying your pretrial conference is before magistrate so-and-so at such and such agency site at such and such time. And often you as the plaintiff don't have to show up to the pretrial conference if you've hired an attorney. Pretrial conference is not where the trial is going to happen. There will be no opportunity there to put proofs before your judge. It's just a time to meet with the magistrate, meet with the other side's attorney, talk about the case, and then get an initial trial date assigned by the judge.
And when you get an initial trial date, you qualify the trial date with the adjective initial because? Because
often there's many trial dates. One exception is a 60-day trial case, and what that means is somebody who's been paid or previously been paid. It's not that the employer never took up your case and paid it. I'm talking now about the situation where for a period of time the employer thought you had a compensable injury and paid it. And the state has said in those cases everybody should be ready to go to trial earlier because the employer has received your medical to initially determine they were going to pay. They must have developed some other medical, perhaps hired their own examiner to determine to cut you off. It's not like the employer needs a lot of time to be ready for a trial. So if you've been paid in the past and now have to file for workers' comp benefits, then you can get a 60-day trial, and actually that first trial date can be an actual trial date where you get to have the trial.
Gary, what's a typical time duration now in 2013 from making your application for hearing to the opportunity to present your proofs before a magistrate?
Typically, and we're not talking about 60-day now.
Yes.
It's a year. The magistrate doesn't really even begin to get frustrated that you're on his or her docket until a year. I mean, they welcome resolution before that. And sometimes resolution can happen short of actually having to go to trial after you've filed the application, because sometimes you've taken the medical depositions and the depositions make clear that one side is very heavily favored to win. And so after working up the case that way, both parties might say, hey, let's end up settling this after all, we don't have to go to trial. But the judge at the pretrial will assign an initial trial date that's probably a date within 2 months of the pretrial. If it's not a 60-day case, the attorneys go to that first trial date, they talk about the case with the judge, let the judge know any updates in terms of perhaps there's some medical records that have been difficult to obtain, or some other issue that's come up, maybe some subsequent work the injured worker's gotten that could affect the tenor of the case. And then the judge will say, okay, I'll give you a new trial date, let's see if we can work that out. And just because there's many cases on a judge's docket for any day, they often do not get to a case and say, you're the one going to trial with me today, until it's gone through a number of those adjournments.
What does some injured worker do while she or he's waiting for this case to wind its way through the system in terms of income or some income replacement to just pay the mortgage or the rent?
Well, the main thing they do, unfortunately, is worry. and call their attorney a lot, saying, when is my trial going to happen? That's the toughest situation, Jim. I mean, there's no good answer, unfortunately. Some people often will try to rely on the goodness of family and friends, but many people do lose their houses during that because it just is too long of a wait to make it happen on a time like that would have been ideal for them.
What about unemployment compensation?
That can help. Sometimes employers, of course, dispute unemployment, and sometimes, especially in workers' comp, they can dispute unemployment. But if you get unemployment, that helps by the time until your workers' comp case is settled. Likewise, there might be some other kinds of additional insurance that you've previously purchased, such as short-term disability or long-term disability. You may have some other insurance policies like that come into play and are able to pay you while you wait. You may even qualify for Social Security disability, although that wait is similar oftentimes.
The unemployment compensation is offset by the insurer or the third-party administrator for the self-insured?
Yes, if you are able to get some other kinds of insurance benefits while you wait to get your workers' comp benefits, hopefully, don't just plan on not being able to double dip. In other words, ultimately, whoever is giving you the money in the meantime, if you get workers' comp, a settlement or a win at trial, there will be things to work out with the people that paid you before, paying them back part or all of what they paid you.
How's that become more complicated in recent years compared to when you started practicing, in terms of those who pay some interim benefits wanting their benefits back from the injured worker after the workers' comp case winds its way through the system?
Well, I think it's happening even just more now.
I agree.
10, 20 years ago, everything seems to be known electronically now. And sometimes those other insurers did not know of their rights or learn of the money that the worker might gain. The agreements that you sign with those other insurers might not have been as tight as they are now in terms of giving the payers that right. If the people that are paying you your interim benefits, they have the option of filing an official lien with the workers' comp magistrate, and if that's in your file, you have to take into consideration their right to have you repay them. Otherwise, a settlement really doesn't go through.
A magistrate won't allow it. And really, you kind of act in your own peril if, in fact, you proceed to settle the case, even if there's not a lien officially in a file, because it might be asserted later.
That's true, and that works with Medicare and Medicaid also. Anybody that's been paying you while you try to get workers' comp, just remember, if you get workers' comp and you've had any other benefits that kicked in because you were injured, you'll probably have to pay those back.
At least you're going to have to resolve it when you come to the point of settling your workers' compensation case.
And sometimes if you take a settlement, you're not taking 100 cents on the dollar, and the expectation for all those other insurers that paid you in the meantime, the expectation would be the same, that they would not get 100 cents back on their dollar. And often you can ask your attorney, the injured worker can ask their attorney to help go to bat for that, and the attorney can also help work all that out with the other payers.
So you've done both sides of the practice, both the plaintiff side, that is the injured worker's side, and the defense side, that is the insurer's side. Let's take it from the plaintiff's perspective first. When this case is pending in the workers' compensation contested case section program, what are you doing as a lawyer for the injured worker?
As a plaintiff attorney?
Yes.
You can take advantage of that time. You wish it weren't so long, but you can use that. And basically, paper records, a paper trail, which sometimes is harder to get when it's only electronic records to begin with, but getting the paper trail, getting the medical testimony needed, and even just and the attorney also offering themselves just to help guide and hold the hand of their client. But what the attorney really wants to be doing is to make sure they have the latest medical, and then when they think they have the medical they need, they often, they have the right, the plaintiff attorney does, to submit those written records into evidence, but often they don't settle for that because the best way to impress a magistrate of the limitations of your client is to actually take the testimony of the medical treater. And so the records are a good starting point, but then often the attorney will schedule the testimony also.